What is the law? Discovering the answer to this question will take you on a personal journey through cosmic time and space. Recently, my law practice involved filing a motion to stay an administrative final order while pending an appeal. After preparing the document, I left my office in Clearwater, Florida to conduct some other business. After a lunch meeting in St. Petersburg, Florida, I stopped by Haslam's Bookstore. Jack Kerouac used to frequent this joint, and legend has it that his ghost sometimes knocks books off the shelf. I saw the best minds of my generation destroyed by the madness. Checking out the law section, I found A Manual of Elementary Law by Walter Denton Smith. Since the book was published in 1894, I knew the book should be freely available in the public domain, so I captured the title and then went to the Internet Archives to locate it. What is the law? Here, the author separates physical laws such as gravity from the laws of human action, which are enforced by sanction. The author's laws of human action are distributed among several legal systems. Laws of human action, sanction. 3. The laws of human action include all systems of laws which are addressed to men as beings possessed of willpower and discretion, and obedience to which is enforced by some form of sanction. 4. Sanction. The term sanction, in its relation to law, signifies the prospect of some evil which will follow disobedience to that law, or of some benefit to follow its observance. 5. The leading systems of laws of human action are A. The moral law, B. The divine law, C. The municipal or positive law, D. International law. Men are, of course, equally with inanimate nature under the control of the laws of physical science. All the involuntary movements of the human organism, as the circulation of the blood, the process of digestion, etc., are subject to them. But, as beings possessed of discretion and willpower, men come under the direction of those other systems of laws which differ primarily from the laws of physical science, in that they lay down rules which may or may not be obeyed, according to the will of the persons to whom they are addressed. For convenience, we will call these last-mentioned systems collectively the laws of human action. Obedience to them, not being inevitable, is enforced by what is known as sanction. The sanction of a law is the means which the author of that law employs to compel obedience to it when such obedience is not inevitable. It may take the form of threats of punishment, as it usually does in the criminal systems. It may be an assurance on the part of the maker of the law that he will compel anyone who violates it to make compensation to anyone injured by such violation. Or it may be of a more indefinite character, as in the case of the moral law. Whatever form it may take, it is the sanction which gives to every law of human action its force and stability. The various systems of laws of human action differ from each other in their mode of establishment, the nature of their principles, and the sanctions by which they are accompanied. Moral law. 6. The moral law is that system of rules of human action which has its origin in a general sense on the part of the members of a civilized community of what is right and wrong, and which finds its sanction in the general disapprobation when any act in violation of it is committed. This system of law is of gradual growth. Its principles are founded on the experience of civilized mankind, and, as that experience grows larger and reflection on it more profound, the system develops. It is assisted in its growth by the precepts and reasonings of teachers and writers, as well as by the doctrines of religion. Depending, however, as it does upon the general sentiments of the members of a community, the moral law fluctuates as public opinion changes, and the morality of one people may differ in many points from that of another of a different race or grade of civilization. The moral law as such is enforced by indeterminate and uncertain authority. There are no tribunals in which it may be administered. There is no power to try formally alleged offenders against it, and no definite punishment attached to a violation of its principles. Yet, in spite of the vague character of its sanctions, those sanctions exist, being found in the general approbation which is felt towards those who habitually obey it, and disapproval towards those who do not regulate their lives in conformity with its doctrines. Divine Law 7. The divine law is that system of rules of human action which men believe to have been established by the ruler of the universe, and communicated to mankind by revelation, and whose sanction lies in the assurance of certain rewards and punishments in the present life or in a life to come. This is the law of religion and faith. According to most religious beliefs, God, having regard to the frailties and weaknesses of human reason, has seen fit to reveal to men certain laws for their government. These laws have their depository in the sacred books of the various religions. Those contained in the Bible are generally received as the divine law throughout Christendom. Municipal or positive law 8. Municipal or positive law is that system of rules of human action established by the governmental power in a state. It may be either written or unwritten. This is the law with which the lawyer has chiefly to deal. It differs from the moral law in that it is laid down by determinate authority and is enforced by determinate sanctions. It is akin to the divine law in the general manner of its establishment, but is distinguished from it by the fact that it is of human origin and human enforcement, and that its punishments are dealt out exclusively in the present life. It is not to be understood, however, that the municipal law, the moral law, and the divine law have no principles in common. Many rules, like those forbidding murder and theft, while retaining the moral sanctions, are also invariably incorporated into the municipal and divine systems. The municipal law is called positive law because it is imposed by an authority having undisputed power to insist upon its observance. A municipal law is a rule of human action as distinguished from a mere arbitrary command. It must be general, applying to all actions of a particular class, not to a single act alone. A mere order or proclamation commanding one to do a certain act would not be a law. But if it commands all persons or a class of persons to act in a certain way under certain circumstances, such an order would be a municipal law, if it is of such a nature that the state will enforce it. A municipal law is also to be distinguished from a contract. Every citizen of a particular state is subject to the laws of that state without assenting to them. So far as the state's authority is not limited, the subject's actions are under its control. On the other hand, a contract is something which the individual assumes voluntarily. The obligations of a contract, when made, have practically the same force as law, because the state will compel their performance, but they originate in the free promise of an individual, and bind that individual alone. The rules of municipal law are established by the governmental power in the state. They may be laid down expressly and formally by a legislature, or, though not so laid down, rules may become law by recognition and enforcement on the part of the authority by which the laws are applied. If established by express promulgation, they are called written laws. If established by recognition merely, the name unwritten laws is applied to them. The unwritten laws are also called customary laws, because they have their principal source in those customs of a community which are so uniformly observed that their observance at last comes to be regarded as necessary to the welfare of the community and is enforced by the state. After swimming in a manual of elementary law, I had to file that motion I prepared earlier in the morning, so I went off to the courthouse.